Good morning, this is your Kelso Report for Wednesday, June 6th, and I'm your host, Clark Kelso. Well, the Ninth Circuit made its long-awaited decision of whether to take in bank its decision in the Prop 8 case. And the Ninth Circuit denied in-bank review of the panel's decision in Perry v. Brown, striking down on equal protection grounds California's Proposition 8, which had limited marriage to between a man and a woman. You'll recall that the panel majority held that Proposition 8, in the unusual historical circumstances in which it appeared on the ballot, resulted from an anti-gay animus and was therefore unconstitutional under the Supreme Court's decision in Romer v. Evans. The decision now sets the stage for the Supreme Court to consider a petition for cert to review the Ninth Circuit's panel decision. We'll wait to see what the court does with that later this year. In a habeas corpus matter, the habeas petitioner in Zhang v. Felker had been convicted of second-degree murder with aggravating circumstances. He received a sentence of 40 years to life with a firearm enhancement, which was reduced on appeal to 15 years to life because of error in the enhancement calculation. The habeas petition here is centered around allegations of juror misconduct and alleged ineffective assistance of trial counsel in eliciting some unfavorable expert testimony on cross-examination from an expert on gangs. The California Court of Appeal had rejected these claims, concluding that the juror misconduct allegations were procedurally defaulted and harmless in any event. There was no error in refusing to order jurors to discuss possible misconduct with defense counsel after the trial had concluded, and the trial counsel's cross-examination was not deficient. Applying the extremely narrow standard of review contained in the Anti-Terrorism and Effective Death Penalty Act, a majority of the Ninth Circuit panel agreed with the District Court that the California Court of Appeal's disposition was sufficiently reasonable to withstand scrutiny. Next, we turn to the California Court of Appeal. First decision dealing with default judgments. Now, as a general matter, a defaulting defendant cannot participate in a prove-up hearing at which the plaintiff presents evidence to support the default judgment. However, in quiet title actions, the applicable statute, CCP section 764.010, expressly prohibits a default judgment absent presentation of evidence of the plaintiff's alleged title, and unless the defendant has been given the opportunity to be heard regarding any claims or defenses. Accordingly, in Nickel v. Matlock, the Second District reversed the plaintiff's default judgment and remanded so the defendants could participate in a pre-judgment evidentiary hearing to determine the merits of the quiet title action. The statutory rule reflects the legislature's concern that quiet title actions, when they are final against the world and deal with real property. Next, criminal procedure decision. The defendant in People v. Mason was convicted of residential burglary and sentenced to life in prison. On appeal, he challenged a $129 criminal justice fee, also sometimes known as a booking fee, that the court ordered him to pay to the city of Sunnyvale. He argued that the fee could not withstand appellate scrutiny because it lacked an ability to pay requirement, and there was no evidence the fee represents the actual administrative costs of booking. Well, the Sixth District rejected both arguments. First, concluding that the Equal Protection Clause does not require imposition of an ability to pay requirement, and second, concluding that the statute does not require the record to contain any evidence regarding the actual administrative costs defrayed by the fee. Next, we have a contracts case involving the sale of goods. Take you back to first-year contracts. In Apex v. Sharing World, the Fourth District reversed pretty much every conclusion the trial court reached after a bench trial involving a breach of contract suit involving the sale of cottonseed. Essentially, the trial court failed to apply Article 2 of the Uniform Commercial Code to the dispute, which led it to make a series of legal blunders in its analysis. For example, the court held there was a lack of mutual assent, even though the parties' course of conduct clearly indicated an intention to make a contract, and the gap-filling provisions of the UCC easily supplied missing terms to the contract. The trial court also incorrectly held that the seller could not recover damages without proving its cost basis in the goods which the seller resold. The problem with this is the UCC clearly provides that so long as goods are resold in a commercially reasonable way, damages are measured by the difference between the contract price and the resale price. You don't need to know the cost basis. The 4th District reversed the judgment and remanded solely for consideration of whether the seller unreasonably delayed its resales. The case is a very good study of seller's remedies in the event of a buyer's refusal to accept delivery of goods under the Uniform Commercial Code. Finally, we have a CEQA case. The plaintiff had filed a petition for writ of mandate and complaint for declaratory relief against the Board of Trustees of the Los Angeles Community College District, alleging that the board had failed to comply with the California Environmental Quality Act in connection with the leasing of an historic campus building. The trial court sustained a demurrer without leave to amend on the ground that the action was time-barred, and the 2nd District affirmed. The basic project approval occurred in 2009 when the board approved leasing of the building for a 5-year period, and the plaintiff had filed an initial CEQA challenge to that decision, a challenge that is still pending in the courts. In 2010, the board made certain implementation decisions, and plaintiff filed a second CEQA challenge to the 2009 project approval. Well, the 2nd District held that this second challenge was time-barred, since it had been filed more than 180 days after the project approval decision, and the decisions taken in 2010 did not trigger the running of a new limitations period or create a new cause of action, since those decisions simply implemented the previously approved project. And that's it for today's Kelso Report. Have a great day in the law.